Welcome, everybody, to this episode of Testable Faith. My name is Fazale Rana. I'm a biochemist and a Christian apologist, and I work for the organization Reasons to Believe that sponsors this particular program. And today I'm joined in studio by Abdu Murray, who is a Christian apologist and also is someone who has a legal background. He trained as a lawyer, worked for a number of years as a lawyer, and today we're going to be talking about how legal concepts can be used in Christian apologetics to advance the case for the Christian faith. So, Abdu, thanks for joining us.
Oh, that's great. I'm so looking forward to this topic in particular. Thanks, Buzz.
Okay, so today we're going to be talking about the Daubert test, the Daubert rule.
That's right.
So biochemist.
It depends on who you ask how to say it, but that's exactly right.
Yeah, and you see that this particular test, which involves really expert testimony, can really play an important role in terms of how we engage people when we're making a case for the Christian faith.
Yeah.
And so maybe the place to start is, what is the Daubert test? What's a little bit of the history of the idea? How does it play out in a court of law?
Yeah, I got to say, it's actually poetic that we're talking about it in a show called Testable Faith, because it's all about the testability of something and what qualifies as bona fide science that a jury can be exposed to in a court of law. So the expert witness rule in the federal rules is Rule 702, and the Rule 702 really codifies what happened in what's called the Daubert versus Dow Pharmaceuticals case, which really was the seminal case in the shift of how expert witness testimony, specifically scientific testimony, is viewed in terms of its admissibility into a court of law. Now, you got to think about the issue here, okay? So if you're talking in a bench trial where a judge is there, a judge might be able to see through, some junk science or some shenanigans if they're sophisticated enough, and that's a big assumption, I suppose, but if they're sophisticated enough to see, this doesn't look like science to me. But a jury might not. They can be dazzled by a bunch of letters after somebody's name and a CV that's as long as a phone book. So that was starting to happen in courts of law, where people were being just dazzled because someone has more qualifications than another person, or they were testifying from what's called the consensus view, or that was like, okay, well, his views align with the consensus of scholarship on this area, so you should give his views more weight than, let's say, some guy who's got a novel theory but might be right. Well, the weight of authority crushes that. And so in the Daubert case, what you had was the Supreme Court saying, we need to shift the test away from a consensus view to what is the methodology someone uses, not just do the majority of scientists agree with their position on something, but what is the methodology? That's the real area there. So when you look at the way in which it had been under what's called the Frye test, Frye, the Frye case basically said, here's the ways you can parse out if a person who's an expert in some field can actually testify in this particular case, so a jury could see it. And it was, do their views essentially match up with the consensus? And in Daubert, they're like, yeah, but you'll never get good science if you always just match up with the consensus. You'll never have progress. And if you can't have progress in science as a field without challenging the consensus, then how could you ever have good science come into a court of law if you can't challenge the consensus? So they said, we need to have some other kind of a test. And so if you read Federal Rule 702, and if you read the Daubert case itself and all its progeny, because a lot of cases, seminal cases, spawn a bunch of different cases because every fact pattern is slightly different, essentially the court is saying it cannot be based on consensus. Consensus is good. You should consider consensus, but it can't be everything. It is the methodology for it. So
in other words, is that expert witness utilizing sound scientific methodology to and has evidence to undergird their non-mainstream position that that they're testifying in?
Right. The jury cannot dismiss you just because you're not mainstream. That's essentially right, as long as you meet certain criteria. And those criteria are essentially that the experts, scientific or technical or other specialized, you don't have to be a scientist necessarily to testify as an expert witness in court. But if the expert's scientific, technical, or other specialized knowledge will help the trier of fact, so it's got to be So it's got to be relevant,
Right.
I could testify as to, the inflation rate of tires given a certain, pump. But if I don't know what I'm talking about, and let's say I'm a librarian and I really know library science, well, what am I doing there testifying about that? So it's got to be the right kind of expert. So that's the first thing. And it's not just based on your PhD level or if you've published or not. It's how you have a kind of background that allows you to be this. I think of my cousin Vinny. If you ever saw that movie, there's a very realistic voir dire. Voir dire is when you find out if an expert's really an expert. Where Mona Lisa Vito, Vinny's fiance, who has no credentials outside of being a hairdresser, is asked a bunch of questions by a highly trained lawyer about why she has any automotive knowledge whatsoever that's pertinent to the case. And she basically says, I worked in the mechanic shop. And then she displays her acumen. She qualifies as an expert, and rightly so. So think about that when you're thinking about what an expert actually qualifies as. It can be a scientist, but not necessarily. The second thing is, though, that the testimony is based on sufficient facts and data. Are they just popping off, or they have actually looked at all the facts and the data, or not all of them, but the sufficient facts and data that would justify them opining on something? And then the third test is the testimony the product of reliable principles and methods, and that's the key. So you have the data, you have a person who knows how to do this, and did they actually apply reliable scientific or the methods and data for that particular field? So in the science field, did you employ the scientific method? Did you do something that a scientist would say, that's how I would do it, or that's how it should be done in that particular field? And then the fourth test is, did the scientist or the expert actually apply those methods to the facts to come to a conclusion that makes some kind of sense? So that's it. But the key part there is the principles and methods. That's the key issue. Why that's revolutionary is because it allows people who aren't in the mainstream of a particular field to testify in court. I mean, think about the stakes we're talking about here. There can be financial stakes, like two companies suing each other, and we're talking millions upon millions of dollars that could affect the future of a company that's providing a really valuable product, or someone's freedom, or even their life if they're in a death penalty situation. So these things are pinnacle issues. So if in a court of law, we have a test that says consensus is important, but it's not ultimate, and we can decide someone's freedom based on that, how much more then can we actually allow for a non-consensus opinion to be at least admitted into court? Now, notice what the important thing here is. The Daubert test does not say you must therefore accord this expert's conclusions to be dispositive. You don't have to believe what that expert says, but you're at least allowed to hear it and consider it. That's the issue in Daubert. You can't exclude that testimony. Now, the jury can say, I believe him or don't believe him.
Right.
But just because he's not a consensus person, the jury is still entitled to hear that person's testimony.
Yeah. Yeah. So to me, this is interesting because I see it being directly applicable to what I do here at Reasons to Believe, right? Where I take a non-mainstream view with regard to the question of origins, right? That I think the origin of life requires intelligent agency to account for it. I think that when we look at the history of life on Earth, there are key transitions in life's history that, again, look like, to me, as if they really require intelligent agency to affect. But yet, oftentimes that perspective is simply dismissed because I'm appealing to agency, which is outside the bounds of science, where methodological naturalism, the idea that you can only appeal to mechanistic explanations really defines what is or isn't a bona fide or a legitimate explanation.
Yeah.
And a lot of times people will say, well, you're outside the consensus, you're not really conforming to science, so therefore we're dismissing your claims as being non-scientific, which in the minds of many people means it's invalid. If it's non-scientific, it's invalid. So there's a lot of issues at play here, but this seems to me a really valuable tool to be able to say, but look, is the methodology sound, right?
Yeah. Well, and it's interesting. A couple of thoughts just started firing when as you were talking. The first thing is, and I've the term methodological naturalism goes right to the heart of what Daubert's talking about. Is the methodology actually the kind of thing that would produce good results? Is it scientific? Right. So one could argue, I would think, that methodological naturalism is so exclusionary to any other part of methodology that it seems to be the antithesis of science. Science is like you have to have rigid and strict, or not rigid, but rigorous standards, but they can't be exclusionary of the possible conclusions. That's the antithesis of science in the first place. Right. And so one could argue that methodological naturalism, as the only game in town, actually violates the Daubert test because it's not. It would be unscientific to exclude things because your method allows for the possibility of agency. Well, that's just unscientific. Yeah. And so I would argue that if I were arguing a motion in a court of law in favor of my expert who actually believes in agents and ascribes agency, supernatural agency to something, and they were to say that can't be included because it ascribes this, like, well, if anybody's testimony here, it's the one that's most includable because that methodology actually comports with science. But if you're going to start excluding things just because of the conclusion that's being reached, that violates the Daubert test. Right. So methodological naturalism, I think, would be excluded if I file a Daubert motion in the court of public opinion, so to speak. Yeah. So I really that's one thought that fired off to me as you were speaking, is that we have to recognize this is not a hurdle, not a hurdle for the believer to overcome. It may be a hurdle for the naturalist to overcome, actually.
Yeah. Well, it's interesting because again, you're speaking about methodology here. And this is, an approach that I've kind of developed and honed over the years, largely in response to engaging non-believers, and skeptics on some of these issues. But it's interesting because there are areas in science where investigators actually look to identify features in the natural record that are the work of agency. Archaeologists who are studying the hominin archaeological record do this. And so I've developed an approach where I look at the criteria they use, which is, does it appear artificial? Can you rule out other reasonable natural process explanations? And then what does it take to produce that particular feature? Yeah. And if it requires intelligent agency, then you've got these three criteria that collaboratively say it looks like intelligent agency. And so using that same methodology, you can look at biochemical systems and draw the conclusion that agency is involved. Yeah. So that's in the spirit of what Daubert is describing, right?
It really is, because it's meant to give the jury as much good information or reliable information so they can make a determination. So you and I are talking to, and by the way, the test strictures apply differently to different audiences. So if you're talking to a lay audience, we would want the Daubert test to be applied in a more rigorous way because they might be dazzled just by credentials. But if you're talking to a scientific community, they already know these things. They can already tell, all right, that's reliable, that's not reliable, that's methodology there. However, I do think as a tool, I think in a presentation, it might be the kind of thing where artfully worded into the presentation is, just because it's not consensus doesn't mean that it can't be admitted in this particular court. In fact, the U.S. Supreme Court, over a very storied jurisprudential history, has said that can't be the criteria. Yeah. It's the methods. So here's my methods. What do you think? Yeah. I think that's a tremendous way to look. That's why I think that the testable model is such an important thing that RTB has contributed, because it doesn't just poke holes in the other view. It actually makes predictions, which is scientific. That's the methodology we're talking about. So I think that's a really tremendous way to be able to advance the argument.
So I mean, I immediately see the value of the Daubert test in my own particular context. Yeah. So what are some other areas where you think the application of the Daubert test might be useful?
Yeah, so the Daubert test actually in the legal field is broad. It doesn't have to be just scientific stuff. It can be of technical expertise, like, the My Cousin Vinny thing about that, like automotive, whatever. It could also apply in historical contexts. So, for example, if someone comes to a conclusion, let's say you take the evidence for the resurrection, and you want to say, okay, these are the facts that, and maybe even use a consensus view, like a minimal facts view, like Gary Habermas, or you take maximal data, like Jonathan McClatchy and some of these guys. Whichever view you take, what you're presenting to the jury, which is the public or whoever you're talking to, or a field of experts who are historians, say, I know that the consensus is that you can't say a miracle happened because that's not historical inquiry. But is it? Here's my methodology for how I get there. Yeah. And you can do that in with resurrection. You can also do that, by the way, in common conversation. So historical inquiry, I think it applies. It's not just science, hard sciences, because there are sciences that are not that are more social sciences or humanities level sciences. So you can do it in physics. You can do it in any one of these areas. Because it all comes down to method. How did you come to the conclusion? Yeah. And we decide almost everything in life based on how you came to that conclusion. So I think it applies to theology and everyday conversations. So I think a value here would be if you can internalize this and you look at these criteria, and then you say, we're going to have a discussion about this. And here's where I think here's some rubrics about why or why not what I'm saying should be considered. Let's go for the first one, second one, third one. What do you think? Do you think that this qualifies as something you should at least listen to? I think you're going to get a really super headway on that, but it applies to everything. So the resurrection, 4 facts, everyone agrees on. What's the conclusion? Well, the consensus says it's not this. Yeah, but the consensus is assuming something.
Right.
They're ruling out the possibility of miracles. But that's the question under examination. Did a miracle happen? Right. You can't rule out the conclusion in your definition. That's question begging.
Right.
And that's not a reliable method. So I think it's so applicable in so many ways. Yeah.
Yeah. So anything else about the Daubert test before we bring things to a close?
No, other than the fact that I really think that using the law and the principles of law, when you think about why the rules of evidence actually exist, they exist to exclude irrelevant and prejudicial evidence, but they also exist to include as much good evidence as possible. So, someone says, oh, he got off on a technicality. Well, that might be true, but that technicality exists for a storied and purposed and principled reason. And the Daubert test is that kind of a thing where it's technical, but it's not overly technical, but it's common sense.
Yeah.
And that's why we have rules of evidence like this. So if it's good enough for a court of law to be in front of a jury, maybe the jury of the public ought to consider it as well.
Yeah. Thanks, Abdu.
Yeah, my pleasure.
All right. Well, thank you so much for joining us for this episode of Testable Faith. I would invite you to go to our website, reasons.org, and search Abdu Murray's name, where you can get access to a whole collection of resources that Abdu has produced for us here at Reasons to Believe. You're not going to be disappointed at what you find. So until next time.